On March 1, 2019, Johnny Depp filed a defamation lawsuit of $50 million against his ex-wife Amber Heard in Fairfax County, Virginia, following an op-ed she published in the Washington Post. Mr. Depp accused Ms. Heard of falsely portraying him as a domestic abuser, alleging that her claims constituted a deliberate misrepresentation that resulted in significant damage to his career and reputation, including his removal from the Pirates of the Caribbean franchise. The case proceeded to a high-profile jury trial, and on May 23, 2022, the defense team for Ms. Heard called Dr. Richard Moore, an orthopedic surgeon, to testify as an expert witness. Dr. Moore was tasked with providing a medical rebuttal to Mr. Depp's testimony regarding a 2015 incident in Australia where the tip of Mr. Depp's middle finger was severed. While Mr. Depp alleged the injury occurred when Ms. Heard threw a vodka bottle at him, Dr. Moore testified that the medical evidence was inconsistent with a thrown bottle and instead suggested what he characterized as a crush injury. Under Virginia Rule of Evidence 2702, expert testimony must be based on sufficient facts or data in order to be considered reliable. When this threshold is not met, the jury may find the witness's testimony discreditable, diminishing the evidentiary weight it carries before the fact finder. During the cross-examination, one of Mr. Depp's attorneys, Camille Vasquez, moved to challenge the very foundation of Dr. Moore's medical opinion.
Good morning, Dr. Moore.
Good morning.
You said you reviewed Mr. Depp's video deposition, is that correct?
That's correct.
And you said you reviewed Mr. Depp's testimony at this trial, correct?
That's correct.
And was that also a video of his testimony?
Yes.
Okay. And you testified that Mr. Depp demonstrated that his hand was flat on a surface, is that correct?
That's correct.
That's not entirely accurate, is it, though?
No, his description was relatively consistent in both, including turning and resting the hand on the edge.
Isn't it true, Dr. Moore, that when Mr. Depp did the demonstration in his deposition, he showed that his fingers were hanging over the bar?
Well, even hanging over the bar, it still leaves the dorsum of the hand or the nail vulnerable.
That's not my question, Dr. Moore. My question is, isn't it true that Mr. Depp said his fingers were not laying flat on a table, they were hanging over the bar?
Yes.
Okay. And in fact, you knew that when you made that opinion. Isn't that correct?
Well, I believe that as I demonstrated sitting here, that I said that he had said they were slightly curled over, I think was the description that I gave.
Your description in this courtroom was that it was laying flat, and I think you've done that now twice. But in your deposition, you testified that his fingers were actually hanging over the bar. Isn't that correct?
Objection, Your Honor. Misstates the witness's testimony. He clearly indicated they were curled. Or could have been curled.
Overruled.
So that's a distinction that perhaps I misstated in one of the two descriptions. However, that does not substantially change my opinion of the impact it would have on the mechanism.
Isn't it true that Mr. Depp also testified that the bottle came from an off angle?
Yes.
Okay. And you consider that in rendering your opinions today, correct?
Yes, I believe he stated that it came from between 6 and 10 feet. I think it was I think he demonstrated it was off to his right. I can't recall specifically, but it was off angle, yes.
Okay. So it didn't come from the top, as you previously testified just a few minutes ago, correct?
Well, no, it would have struck the top of the finger, but it may have been slightly off angle in its approach based on the description.
Mr. Depp described it as off angle, correct?
Correct.
All right. Dr. Moore, just at the outset, your billing rate for providing deposition testimony is $1,000 per hour?
That's correct.
All right. And you were deposed in this action for several hours on March 22nd, 2022?
That's correct.
And your billing rate for providing trial testimony is $5,000 per day?
That's correct.
You were retained in this case by Ms. Heard's legal team, correct?
Correct.
And over the last few years, you've provided expert services for one of Ms. Heard's law firms on at least 2 other cases, right?
That's correct, yes.
Dr. Moore, is it fair to say that you have no personal knowledge as to how Mr. Depp injured his finger in Australia, correct?
No, I have no personal knowledge. My impression is based on his description of the injury and the available medical records for review.
But you weren't in Australia with Mr. Depp and Ms. Heard, correct?
I was not in Australia, no.
And so therefore you have no personal knowledge as to how that injury was sustained?
Correct.
All right. You also never personally examined Mr. Depp's finger, did you?
Correct.
You didn't examine Mr. Depp's finger at the time it was injured.
I did not.
And you never provided any medical treatment to Mr. Depp in connection with his finger injury, did you?
I did not.
During the cross-examination, Ms. Vasquez questioned Dr. Moore regarding his hourly billing rate and his professional relationship with Ms. Heard's defense firm. While Code of Virginia 8.01-401.1 permits an expert witness to render an opinion based on facts made known to them prior to trial, the law also grants opposing counsel the right to expose the financial interest of that witness. A witness's financial interest in the outcome of litigation is considered relevant to their credibility, as it may bear on the objectivity of their conclusions. By revealing that Dr. Moore maintained a pre-existing professional relationship with Ms. Heard's defense firm, Ms. Vasquez sought to characterize him as a so-called hired gun, whose medical inferences were purchased rather than grounded in independent clinical observation. This line of questioning effectively challenged the probative value of his testimony, suggesting that his conclusions were shaped by loyalty to repeat employers rather than by objective medical facts.
Now, you've testified that you identified Mr. Depp's finger injury as a crush injury, correct?
Correct.
And a crush injury is when a body part is crushed or trapped between two opposing firm surfaces, yes?
Yes.
And a crush injury to a finger can occur when a foreign object hits the finger, right?
Yes.
And based on the pictures that you reviewed of Mr. Depp's finger injury, you cannot determine what particular object caused the injury to his finger, yes?
Well, I can't determine exactly what object did it. I think that I can say with confidence that the described mechanism of the bottle hitting and shattering the finger was not consistent with the appearance of the injury.
I understand that.
And
My question is just very specific. You can't determine the object that caused the injury to Mr. Depp's finger.
Well, it's a little bit more of a non-specific answer. I mean, I can't determine the exact object, but I can determine that it's unlikely that it was sustained in the manner described.
A bottle is a foreign object, isn't it?
Yes.
Okay. So you can't rule out that the injury to Mr. Depp's finger was caused by a vodka bottle, correct?
Well, based on the injury pattern, I can say that the described mechanism of injury is inconsistent with medical findings.
Right. But because a vodka bottle is a foreign object, you can't rule out that a vodka bottle is what caused Mr. Depp's injury.
Well, I can't rule out that a vodka bottle caused the injury, but I can rule out that it was caused in the manner described in his testimony.
You can't rule out that the injury was caused by a knife, right?
I think it's unlikely that the injury was caused by a knife.
But you can't rule it out.
Well, if a simple knife laceration wouldn't impart the injury to the distal phalanx to result in the comedy fracture. Now, a chopping type, but again, that would likely come from a direction that would create a dorsal injury to create the fracture that was developed.
Do you remember giving testimony in this case, Dr. Moore?
Deposition?
Yes.
Yes.
Okay. Line 4.
Correct.
Question, but you can't rule it out completely, right? Answer, I can't rule anything out completely. I can't rule out that he caught it in the door, cut it with a knife, or slammed it in the car door. Or, again, as Dr. Gilmore said, we can't definitively say what caused this injury. Did I read that correctly?
You did.
Okay.
Your Honor, I would object as to the incomplete impeachment. I think if she's going to read his answer, she also needs to read or give Dr. Moore the chance to read the paragraph below. She just picked out half of his answer.
You can redirect.
Yeah, as
overrule the
well as the
objection.
paragraph above.
Dr. Moore, there's no question pending. Thank you, though. So you can't rule out that the injury was caused by a car door either. Is that right?
Correct.
Okay. But it's your testimony sitting here today that you can rule out that the injury was caused by a vodka bottle. Is that your testimony?
My testimony is that I can rule out the injury as caused by the mechanism described by Mr. Depp in his deposition.
But you can't definitively say what caused the injury to Mr. Depp's finger.
Well, the definitive injury is a crush injury, but again, I can't say. I mean, I think that it's quite likely that the initial mechanism described at the time of presentation of the accordion doors would classically create this injury pattern. You know, the hand up in front. If you picture accordion doors as the edge is closed, if the hand's up, the palm is exposed. If the door's pushed, and the
Dr.
hinge
Moore,
closes about the fingers.
I understand that. But my question is,
I think it's important that they understand that.
this is the time for me to ask you questions. Your counsel will have the ability to rehabilitate you and ask you questions on redirect. Right now, let's try my question.
Okay.
You can't definitively say what caused the injury to Mr. Depp's fingers. Yes or no?
No.
Okay.
Ms. Vasquez then proceeded to impeach Dr. Richard Moore by pointing out the conflict between his testimony at trial and his sworn deposition testimony from March 2022, in which he acknowledged that he could not rule out a thrown bottle as the cause. Impeachment is the process of challenging a witness's credibility, which may be accomplished by demonstrating that the witness's account has changed over time. Under Virginia Rule of Evidence 2.801, a witness's prior statement is not treated as inadmissible hearsay when two conditions are met. First, the witness must be testifying at the current proceeding and be subject to cross-examination. Second, the earlier statement must be inconsistent with the witness's current testimony and must have been made under penalty of perjury, such as during a deposition or a preliminary hearing. When these requirements are satisfied, the prior sworn testimony may be introduced to demonstrate that the witness is contradicting themselves. In this instance, because Dr. Moore had previously testified under oath that he could not rule out the bottle as the cause of the injury, Ms. Vasquez was permitted to confront him directly with that transcript. This allowed her to highlight the inconsistency for the jury, effectively undermining Dr. Moore's expert reliability and weakening the evidentiary foundation of the defense's medical narrative.
In conducting your analysis of Mr. Depp's finger injury, you did not attempt to reconstruct the incident. Is that right?
Well, I think the incident was reconstructed. You mean did I throw a vodka bottle at something?
No, no, Dr. Moore. I mean, you didn't do any type of accident reconstruction, either computerized or you didn't conduct any type of accident reconstruction of the alleged.
No, that's correct. My opinion is based on the medical records and the clinical images and Mr. Depp's description.
And your analysis is based on an understanding of how Mr. Depp described the exact position of his finger at the time of the injury, yes?
Yes.
Okay. And your analysis is also based on the assumption that Mr. Depp's hand remained completely still in the instance that a vodka bottle was hurled at him, yes?
No, my assessment is on his description of the vodka bottle striking the top of his finger.
But his hand stayed still, according to your analysis, yes?
I guess it was still long enough for the bottle to hit it, but natural reaction would be to try to pull away.
When you perform traumatic finger surgeries, you inquire about the cause of the injuries, correct?
Correct.
And your best information on that is typically just the self-report of the patient, yes?
Correct.
And your assumption is that the patient is trying to get care. Because the patient is trying to get care, that patient is generally telling the truth, right?
You would hope so.
Yeah. You reviewed Dr. Kipper's deposition testimony informing your opinion about Mr. Depp's finger injury, correct?
Correct.
In forming your opinion, did you consider Dr. Kipper's deposition testimony that while Dr. Kipper was providing emergency treatment for
Objection,
Mr.
Your Honor.
Depp...
May we approach?
Okay.
Let's start over, because it's important the jury hears this. So in forming your opinion, did you consider Dr. Kipper's deposition testimony that while Dr. Kipper was providing emergency treatment for Mr. Depp's finger injury in Australia in the driveway of the house, Mr. Depp told him that his finger was injured when Miss Heard threw a vodka bottle at him?
I don't recall that from the deposition. I'd be happy to review it if you have the deposition available.
Did you consider Dr. Kipper's testimony that he recalled that Mr. Depp's finger was found in the kitchen?
I do recall that.
So you must have also seen Dr. Kipper's deposition testimony that he wasn't the one who actually found the finger, correct?
That's correct.
Dr. Kipper testified that someone he thought was the chef told him he found the finger in the kitchen area, correct?
I'm going to assume so without reading the deposition now.
Did you review any testimony from Ben King in rendering your opinions today?
Not to my knowledge, no.
Did you see any of Mr. King's testimony at this trial?
I did not.
Okay. So you're not aware that Mr. King testified that he is the one who found Mr. Depp's finger, are you?
No.
And you're not aware that Mr. King testified that he found Mr. Depp's finger in the bar area, right?
Correct.
And you're not aware that Mr. King testified he found Mr. Depp's finger in a piece of tissue in the bar area, either?
No.
And you're not aware that Mr. King testified that multiple broken liquor bottles were also found in the bar area, right?
Correct.
If we could please pull up Defendant's Exhibit 1817, which is already in evidence. Have you ever seen this picture before, Dr. Moore?
No.
So you're not aware that this is the bar area where Mr. King testified he found Mr. Depp's finger?
No.
Okay. Do you see that broken vodka bottle in the back corner near the bottom of the bar?
Yes.
Okay. Do you see the blood drops on the floor?
Yes.
Can we please pull up Defendant's Exhibit 1820, which is already in evidence? Have you seen this picture before, Dr. Moore?
I have not.
So you're not aware that this is also a picture from the bar area where Mr. King testified he found Mr. Depp's finger?
Correct.
Do you see the bloody tissue on the ground at the bottom of the bar?
Yes.
Do you see the blood drops around that tissue?
Yes.
So you didn't consider any of this evidence in rendering your opinion about how Mr. Depp injured his finger in Australia, did you?
I did not.
Ms. Vasquez further contended that Dr. Moore's conclusions suffered from a fatal lack of forensic foundation, specifically citing his failure to conduct any computerized or mechanical reconstruction of the incident. From a legal standpoint, she was highlighting a significant analytical gap in his methodology. Under Virginia law, as established in Titworth v. Robinson, a reliable simulation or reconstruction must meet substantially the same conditions as the event in question. Without such a simulation, Dr. Moore's opinion on the physics of a shattering bottle remained, in Ms. Vasquez's framing, a theoretical hypothesis rather than a scientific certainty admissible as expert knowledge. While Dr. Moore defended his position by pointing to what he described as the objective clinical reality of the medical records, Ms. Vasquez effectively framed this as a selective review of the available evidence. By exposing that Dr. Moore had failed to account for the testimony of Ben King, who had found the severed digit in the bar area, she demonstrated that the expert's crush injury theory was built upon an incomplete factual basis. In doing so, the defense successfully moved the testimony out of the realm of expert knowledge and into the realm of inadmissible speculation. This tactic forced the jury to choose between a doctor's static interpretation of photographs and the dynamic first-hand accounts of the witnesses who had actually navigated the forensic aftermath of the incident in Australia. On June 1, 2022, Ms. Heard was found liable by a Virginia jury on 3 counts of defamation, including a finding of actual malice in connection with her claims of domestic abuse against Mr. Depp. Ms. Heard was ordered to pay $10.35 million in total damages. After accounting for a $2 million award granted on Ms. Heard's counterclaim, both parties sought to avoid the uncertainty of a lengthy appeals process and the possibility of remittiture, which is a court's reduction of a jury's damages award when it is found to be excessive. In December 2022, the parties reached a post-judgment settlement and release agreement. Ms. Heard's insurance carrier paid Mr. Depp $1 million to resolve all remaining claims. This arrangement allowed both parties to withdraw their respective appeals, while keeping the jury's finding of liability intact. Mr. Depp subsequently pledged to donate the entirety of the settlement funds to charity. This proceeding highlights a fundamental tension in the adversarial legal system, the balance between expert medical opinion and the forensic reality of traumatic injury. During the cross-examination, Ms. Vasquez exercised the full force of cross-examination to demand precise answers and expose the gaps in Dr. Moore's reconstruction of the Australia incident. While Dr. Moore maintained that his orthopedic analysis supported a crush injury theory, the exchange underscores why expert testimony is subject to rigorous scrutiny under the rules of evidence. The confrontation also underscores why witness credibility is paramount in high-stakes litigation. Testimony derived from static photographs rather than physical examinations can create the appearance that an expert may be unduly influenced by the party that retained them, or that a scientific conclusion may be reached without full consideration of the surrounding circumstances. By permitting this line of questioning, the court preserved the jury's ability to distinguish between impartial science and a narrative crafted in service of the defense. Together, the events in this case illustrate how the legal system must constantly balance expert authority, attorney cross-examination, and the procedural safeguards designed to ensure both forensic accuracy and the appearance of fairness. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe and share as we continue working to promote a more informed society.